Yep. Good morning. We're here for the final case on the docket, Gallon Care versus Schmidt. We're ready when you are.
May it please the court. Jason Azar on behalf of Gallon Care. We are the petitioners in this action where we have filed a petition for writ of certiorari stemming from the lower court's denial of our motion to dismiss for what we felt was the failure of the plaintiff to comply with Florida's medical malpractice pre-suit statutes. And as the court is aware, there are a multitude of issues that have been presented in the briefs. I feel the main issue, unless your honors are going to.
I've got one preliminary question.
Yeah, I figured.
Can we address the elephant that walked into the room a couple months ago, the Carmody case out of the Supreme Court?
Yeah, the Carmody case is that was an interesting one, wasn't it? So I read the case again last night, trying to understand what the Supreme Court did. And we've had some arguments in my office about what the impact of this case was. And essentially, I think what the Supreme Court did was said that the trial court in that case went a little far afield of what they can do in determining whether an expert is qualified to render an opinion in that case. Because in the opinion, it says that the court conducted discovery on the issue and took depositions on the issue. And I've never seen that in all the years I've been doing this with the medical malpractice. I've never seen any judge at the circuit court level actually do any type of discovery on the issue.
In fairness to the circuit judge, though, these qualification issues, the way they get teed up and the way they get brought before the circuit court, the way they end up coming before us and served, you can kind of understand why, right? I mean, these things get really deep in the weeds about levels of qualification, who can upon what and upon what defendants.
And before I go any further, Judge Lucas, I'm sorry, I'd like to reserve 5 minutes for rebuttal. Thank you, Judge. You know, you're right. And I think when you look at what qualifies an expert in order to come to pre-suit, before we had the statute that said same or similar, and that really opened the doors to a lot of discussion. And again, coming in with a cold record, when the legislature took out the similar and said it's got to be the same specialty, I think it kind of cut it down. But if you look at the four corners of the NOI and the expert's opinion, you can generally tell if they're qualified or not, if they are the same specialty. You're going to have those types of cases where, well, he's a neurosurgeon. I think it's one of the cases cited. You're a neurologist. You both work on feet. Well, you're the same. We don't have the same training, but we do the same thing. That's where it kind of maybe get into a little bit of the muddied waters. But I think overall, generally, 90% of the time, just looking at the circuit court, just looking at the affidavit, the CV can pretty much tell if it's the same specialty or not. I mean, you know, we're not talking about the cases that come before your honors aren't the cases where you have a podiatrist trying to render an opinion as to a emergency room physician. You know, you don't have that. It's more those close calls where I think, and I think in the Carmody case, what happened was you had one of those close calls, and the circuit court decided, look, I need to expand my review and what I can do, and on and allowed depositions, which again, I've never seen in the pre-suit context of an expert. In fact, most of the case law I read says that's absolutely not permitted. You don't really get to the deposition until such time as you're doing your motion for determination after the same expert has been deposed once suit has been filed. That's kind of where you see that, not in the beginning stages like where we are here. And I think what the Supreme Court did was recognized, similar to what they recently did with punitive damages, was recognized, look, we need to be able to review this. There's got to be some way of reviewing the qualifications a little more expansively than what we have, similar to what they did with punitive damages, where it was only allowed to say, okay, did you follow this format? We can't really look at the evidence. I think what the Supreme Court is saying now is we need to be able to give the DCA's and the Supreme Court's the ability to look at this qualification a little more closely on those cases that are close. So I think that's why you have that case saying, well, it wasn't permitted then, we're going to amend the rules and we're going to do it now. And I think that's the right decision. I think that the protections afforded by the Medical Malpractice Act are that important. And you get to a point, and I think this kind of dovetails into what I think is the real issue here today. The plaintiff's bar, when filing a claim for medical malpractice, are of the opinion, I get one expert. If I get one expert to say there is medical negligence, that's all I need. I just need one. I don't care if I'm suing 10 doctors, I just need one. And I kind of brought this up in my petition. You know, you can theorize the situation where you have a patient come in to a hospital in an emergency room setting, sees an ER doctor, ER nurses, has surgery for some reason, and then receives physical therapy from a physical therapist at the hospital. And somewhere along that line, there's medical malpractice. Under the theory of the plaintiffs in this case, the one practitioner theory, they could say, well, we have a medical malpractice claim against the physical therapist, and that's all I need to do to get through the courthouse door. And that's not really what the Medical Malpractice Act says. And it's not really what it stands for, because you have different providers, and all of those providers need to be afforded the same protections of the Medical Malpractice Act. Do they do the investigation? They need to know that they may be on the hook.
Does it make a difference that we bring a claim directly against the provider as opposed to bringing a claim against the hospital vicarious liability?
And that's the second big issue on this one. And we say no, there shouldn't be, because if you're suing a hospital, you can't do indirectly what you can't do directly. If you're going to sue the provider, you have to file the Medical Malpractice Act. Why shouldn't those protections apply to a hospital as well? If you're going to say, in my scenario, well, we think that everyone took part in this malpractice, from the ER doctor to the ER nurse, to the nurses on the floor, to the physical therapist. If you're going to sue a hospital for vicarious liability, it shouldn't be, well, we get to pick one and we're good. No, what should happen is you should put that hospital on notice to say, we intend to sue you vicariously for all of these providers, and have an expert review and say whether or not there is a claim for medical malpractice. Because the flip side of that, Judge LaRose, is if they don't, then what are we thinking here? Okay, well, maybe they had an expert review everything, and that expert, he really doesn't think that there's medical malpractice from the ER. The ER doctor did everything they could. But just doing pre-suit as to the physical therapist. Now, we don't know if there was an investigation done. We don't know if there was a review by an expert for those other providers. So it shouldn't matter. It shouldn't matter that it's a hospital. And I'm fairly confident in the Mann case, this court essentially said that. They had a case where it was TDH, and the amended complaint came in, and it was vicarious for a hospital. And this court said, no, you have to pre-suit everyone. You have to give everyone notice. You have to give the hospital notice of everyone who's coming in here. Everyone who's going to be sued, you have to give them notice. Now, in the petition response, I know the argument is that, well, we don't have to tell you everything. We don't have to try our cases, essentially. We're not saying that. We're not saying you have to try your case. But what you do have to do is tell us who are responsible for it. Because there may be a situation where we think that one provider, there may be a good claim, and we want to avail ourselves to the protections of the Medical Malpractice Act, but maybe there's some that we don't. And what is the hospital left to do? Guess? We have to guess on who's going to be sued and what they're going to be sued for. And I think those are the real issues here. This court has consistently held in multiple cases, including the Jackson
Sorry,
case.
I hate to go back to the original question.
Yes, sir.
But I'm still troubled by Carmody, because you dovetailed into the policy issues and what your position is on that. But the whole of the case is that we can no longer use certiorari to review qualification issues.
Well, we're not really asking for that. In essence, we're not. Part of our issue, part of our argument is a qualification argument,
Yeah.
but part of ours is you didn't even do pre-suit. Now that's a completely different animal. We're saying you did not pre-suit the critical care specialist. You did not pre-suit the physician's assistant at all. That doesn't get
And
touched
the
by.
PA is not named as a defendant.
I don't know. These are all vicarious.
Right.
These are all vicarious. So again, going back to what Judge LaRose said, they're trying to do indirectly what they can't do directly.
And that, that may be, maybe call your legislator, I don't know.
Yes.
But on the issue of the subject compliance with qualification, can we agree Carmody's kind of has put that off? That this resolved, we can't reach that anymore.
Your Honor, I don't know the answer to that question because it's procedural. So where it's procedural, do we go from the day of the order? Do we go from the day of the petition, or do we go from today? Because the court is saying it's procedural, which means we go from the time it's being decided. Does that mean now this court can open the door and absolutely look at the qualifications? I think there's an argument to be made there. I don't know the answer to that question, but I think if you look at it, there's a good argument on either side.
Color me initially skeptical to that, but I'll be open to persuasion, but
Well,
I'm not really sure.
again,
Two different, this is how jurisdiction gets, and those are just two categorically different animals, certiorari and a
yes,
non-final order appeal.
and
And there's no indication before the Supreme Court that they meant for the simultaneously adopted rule amendments to be retrospective implication.
I understand your point, Your Honor. I do, and I struggled with that myself. And in trying to prepare for this today is to say, okay, well, if that is true and that is correct, does this entire appeal go away? And it doesn't, because again, the qualifications of the expert are one aspect of the arguments that we're raising. There's also the argument of you didn't comply with pre-suit at all, and I don't think Carmody touches on that. And with that, I believe I have just about 5 minutes left.
You've got, excuse me, you've got 8 minutes left. That includes your rebuttal time.
Thank you. Okay.
So I have a question
Yes,
for
sir.
you though, because there are certain things about the TGH case I'm not certain where I'd land on, but here's the question I had. For purposes of pre-suit, you have a viable claim against the hospital. Your client has moved to dismiss, saying insufficient. Could this have been handled, or could this be handled as in some fashion, a motion in limine saying they can't bring in any of this information about these other people? And if the trial court says, no, they can bring it all in, I think there was sufficient pre-suit, I've already ruled there's sufficient pre-suit, wouldn't that be reviewable on appeal post-judgment?
So you're saying in the context, hypothetical context of a motion in limine, we're going to allow the discovery, we're going to allow everything.
Based on what the trial court has done to this point, if we feel that certiorari jurisdiction simply doesn't lie at this point in the case, would you be precluded from filing a motion in limine saying, Judge, we know you ruled against us on a motion to dismiss, but this information shouldn't come in because the experts never really identified this person?
So I have a few answers to that, if you'll indulge me for a moment. The simple answer is no. There's nothing to stop us from doing a motion in limine and having that raised on appeal. However, what that scenario does is the same scenario as if we wanted to file a motion for summary judgment. Let's just suppose that the plaintiffs in the case use the same expert. We're able to go and depose that expert and say, hey, did you look at this? Did you look at the critical care? Did you look at the physician's assistant? No, I didn't. Now we can file either another motion for determination or a motion for summary judgment. Again, denied, we can do that on a plenary appeal.
And if the doctor says, yes, I did, that also gives you an argument that they didn't put us on notice when they should have, when the doctor himself or herself.
Yes, exactly. But what do those two scenarios do? Those two scenarios negate the whole reason why the courts allow certiorari in these types of situations, because if there's no pre-suit, there should be no case.
But there has been a pre-suit and there is a case. The case goes forward one way or the other based on at least what the expert opined in writing.
But again, you're taking away the protections of the hospital's protections under the Medical Malpractice Act. We're allowed to say, okay, there's nothing
Now
saying
that we know there's this other potential liability.
Right.
We really do want to settle as opposed to.
or we want binding arbitration. And there are protections where if we offer arbitration and it's denied, there are protections for that. And your scenario takes those away. That's the entire reason the courts have said prior to this, certiorari lies for these types of situations, because if we don't address this now, the protections of the Medical Malpractice Acts are nullity. They're not going to do anything. They're going to be ineffective. That's why there's no way to remedy it on appeal. We're going to make you go through the entire lawsuit and say, oh, you shouldn't have had to worry about the nurses. You shouldn't have to worry about critical care. You shouldn't have had to worry about that physician's assistant, but we've already have. This case, and this is my last point, and I'll save the remainder for rebuttal. In this case, one of the arguments raised, which goes to your point, well, the hospital's in it already. You're right, the hospital's in it already. We're already in vicariously for a few of the doctors. But again, the point is, where are the protections? We need to know who we are required to defend, who we may be on the hook for, so that we can make that informed decision. Without the investigation, without knowing, we can't do that. And that's why we believe that the lower court erred in denying our motion. And I'll reserve the remainder of my time for rebuttal. Thank you, Your Honors.
Very good. You'll have your 5 minutes, and Mr. Gowdy, you'll have 20 minutes.
Good morning. May it please the court. Brian Gowdy on behalf of the Schmidt family. Your Honor, I'm going to make, there's 3 points that I'm going to try to make, but really the first point, which Judge Lucas has already alluded to, is where you have to stop. You don't have to do anything else. But my main 3 points are: 1, under Carmody, this court cannot review this case. And I'll go more into that in a moment. 2, under the plain language of 766.2032, and not all the policy arguments we just heard for the last 10 minutes, the reasonable corroboration is to the named defendant, not unnamed providers. It is to the named defendant. And therefore, there is no requirement in the plain text of the statute to corroborate every single possible instance of medical negligence. And I'll go more into that. Number 3, if we get there, which I don't see why you need to, because this is a pretty complicated steps on how to read these 4 statutes together. Non-Florida physicians, like the 2 experts we had here, are allowed to testify on medical support staff. But let me go back to number 1. In the Jackman case, which Judge Lucas, you were on the panel, it was per curiam, the court said this, and Jackman's going to come back because it went up, you certified it, it's hanging on, and once everything gets cleared out from Carmody, you're going to see it again, I suspect. But this court has consistently held, this is what the panel wrote in Jackman, this court, meaning the 2nd District, has consistently held that denying a motion to dismiss where pre-suit corroboration, expert corroboration is insufficient is a departure from the essential requirements of law. And you cited the Mann case, which Judge LaRose was on. In Carmody, that was directly overruled. The Florida Supreme Court made it clear that it agreed with the 1st District in the result, got there with a little different rationale, but said that the sufficiency of an expert affidavit is not susceptible to certiorari review because it cannot be a departure from the essential requirements of law. Now, I want to read the order that you're reviewing. It was made orally. There are sufficient findings here. And then the judge said in her written order as stated on the record, I'm going to find the qualifications of Dr. Levin, or at least facially sufficient to give the opinion. That's the order they're seeking review of. So, and then she says later on, the judge, I think the affidavit is sufficient. I'm also going to find the language in this pre-suit, I think she meant to say affidavit, is sufficient. sufficient to the point to include the staff of Brandon Regional Hospital and its agents. So we now have most of, and to my friends, you know, when the reason I asked for oral argument, I figured Carmody would come out done after briefing, and it did. All the authorities he relied on in his petition, Mann, Jackman, were overturned by Carmody. So you can't decide this case. It's that simple. And unless the court has any questions about the effect of Carmody, I'm going to go on to my other 2 points, but which might help you on a future case, because I think you're going to see these issues again and again. I just heard policy argument after policy argument after policy argument as to why they need to know about every single provider's negligence. Keep in mind, in many medical malpractice cases, when you go into a hospital, so I'm sure everyone's had that experience, you get touched by multiple providers. In this case, it was probably 8 or 10, if not more, providers. And of course, so I say all that if you want to get to the policy arguments, but let's just stick to the text of the statute, and it's 766.2032. I got too many papers here. Subsection 2. This is what it says in the statute about the pre-suit investigation. The claimant shall conduct an investigation to ascertain that there are reasonable grounds to believe that, 1, any named defendant. Now, I've read Jackman, I've read Mann, and nobody pointed this particular language out to you in those cases. It doesn't say any provider. It doesn't say anybody for whom the hospital could be held liable. It says named defendant. We have one named defendant here. It's the hospital. We've not named the physician assistant. We've not named the critical care specialists who we don't even know their names yet. We have not named all the providers. We don't have to. And it says in the statute, we have to reasonably corroborate there's reasonable grounds to believe that any named defendant in the litigation was negligent in the care or treatment of the claimant. As you pointed out, Judge Silverman, we've done that. It's undisputed. And you also have to show the negligence resulted in injury to the claimant. There is no requirement in this statute to state every instance of negligence. There was never a meaning, and I laid it out in my response. The corroboration requirement is to ensure that this is not a baseless lawsuit. It's not a substitution for the rules of civil procedure and the complaint, or for section 57-105. And we, at the beginning, limited our claims based on what we knew in pre-suit, but I see this time and time again in medical malpractice cases. You get into discovery, you learn additional facts that you didn't know, and therefore it could be that you plead additional instances of medical negligence against an individual or corporation. For example, we cite the Davis case from the 5th District, where originally the allegation was that the surgery was negligent. And then at some point in the lawsuit, you realize it wasn't just the surgery, it was the post-surgical care that was also negligent. And the standard rules kick in. And as long as you're not bringing in a new defendant who didn't get the benefit of this isn't a new defendant, it's the same defendant. You're allowed to do that just like any other civil case. The other case that's out there is the JFK Columbia case from the 4th District. In that case, there was a negligence by the OBGYN a day before the patient went to the emergency room, and there was negligence in the emergency room. The pre-suit affidavit dealt with only the emergency care. And the 4th District said that that was sufficient because the purpose is not notice. I heard this again and again and again. If you go back through all the statutory history, it's corroboration. That's why we have the affidavit. They get the notice of intent. That's a separate document. So there's just no requirement in the text of the statute. And I will say, in all candor, I litigate this all around the state, and in this district, based on Jackman and Mann, I hear the same argument. It's bare, and what we hear is the same thing. They go and they dig out the complaints that aren't in the opinion, and they try to say that the 4th district is wrong in JFK and the 5th district's wrong in Davis. And at some point you may get to that, have to deal with that. I will point out this court in Bonatti, which is the first case they cite, and which started all this, Bonatti cited Davis and actually said exactly what Davis has cited all around outside the 2nd district for, which is that you don't have to plead in the pre-suit affidavit every instance of medical negligence. And this court said that in Bonatti. But I'll admit that since then, these decisions, Mann and Jackman, seem to go elsewhere. At this point, I think both those decisions are no longer good law in light of Carmody, at least on the procedural context. I don't know how much time I have left.
11 minutes.
Okay, if I've gone over the first 2 issues, if the court doesn't have any questions, I'd like to tackle the last one. And if it would be all right, and I have one for opposing counsel, because this is so confusing, I kind of wrote this out, and if I could approach and give this to the clerk, would that be all right?
You know, I had a note about Bonatti, and I wanted to clarify one thing
Yes.
about it. In Bonatti, wasn't there a defendant who was actually named for whom there was no corroborating affidavit?
Bingo.
Yeah.
That's-
what I think.
That's so, and we wouldn't disagree with that. We're not disagreeing with the holding of
That
Bonatti.
was it was a party.
Right. You can't, if we, just for example, in this case, the physician assistant who's unnamed and is not a party, but for whom we say the hospital is liable. If we brought him into this case, we would have to have an affidavit that covered him. Now, we think these affidavits do, but that would be what he's entitled to. It's the named defendant. Okay, it's not every claim, doesn't say that here. It's nowhere in the statute. So you're right, with Bonatti, if we brought the physician assistant in, we would have to, for his rights, we would have to comply with this. And it would only, obviously, we couldn't hold the physician assistant, he was a neurosurgical physician assistant. We couldn't hold him liable for what, the emergency folks people did in another part of the hospital. At least not necessarily, right? We have to focus on whether his standard of care. So,
Well, I want to ask you the same basic question I asked the hospital's lawyer, which is, well, I want to intro it. So the introduction is you have vicarious liability, which is based on an unnamed defendant's or one unnamed defendant's, potentially one unnamed defendant's conduct. And it is troubling that Bonatti doesn't really address it. And I don't think any cases directly say, well, vicarious liability, as long as you've named the hospital, you don't have to worry about others. And maybe you've got a case that directly deals with that. But I'll go to the point of some of these issues can be resolved on appeal if information comes in for which the hospital would have had no clue that there was potential liability for a particular non-named party or non-named individual conduct.
right. So I heard your question to him, and I would agree. I mean, I don't think we need to get here either. We make the irreparable harm argument, which is separate from departure from essential requirements of law. And I agree with you that these things could be corrected on plenary appeal. I think I would just I would disagree with some of the premise of what you're saying. The primary vehicle for getting notice is the notice of intent, but even under that, it's not that you get notice of every provider or every instance. The way you would get notice before trial is through the complaint. We go back to the good old rules of civil procedure. And the pre-suit is an exception to the rules of civil procedure, but you've got to show where in the statute you fall under that exception. And, I hear all this like, oh, this is going to be terrible. Well, it's the same rules that everybody else in the state follows. And the reason that plaintiffs' lawyers don't put these in the initial complaint is they actually are carrying out their good faith obligation of just not naming every single provider under the sun. And so now we're hearing, because we don't do that, oh, that's it. Once you're done with pre-suit, you can't add any other instances of negligence. You can't name any other providers. I'll just tell you, I've done a lot of these cases too. And also about the discovery, I see it all the time. I completely disagree with my friend on that. In fact, this court's case law, Holder and the Williams v. Oken case from the Florida Supreme Court, talks about you need to have evidentiary hearings for these issues. Well, if you have evidentiary hearings, what do you think you have before? You have depositions. So I'm not sure, maybe they aren't asking for them, but in the cases I handle, I see these. And the point being that is that as far as the pre-suit, Your Honor, it's only to ensure that there's not a frivolous lawsuit or a baseless litigation that's filed against the defendant. And they've conceded that hasn't happened because they're not challenging the affidavit. So I'm sorry, I don't know if I hope that answers your question.
Well, considering there were multiple parts in different directions, we did fine addressing it.
Can I hand you this? I'll try to be quick with it, or if not, it's
Like a demonstrative.
it is a demonstrative.
Back my childhood.
This goes to what I don't think the court's going to get here on this case because of Carmody, but there's a lot of confusion.
It won't be long for lack of demonstratives.
This deals with, in a lot of these cases you read, you'll see this, and it came up in Mann, where you have, usually you have out-of-state physicians as expert witnesses. I think you can see why that is. It's difficult to get a Florida physician to testify against another Florida physician. And so there's a real question though about their ability to testify, an out-of-state physician to testify against what I'll broadly call medical support staff. And that's nurses, nurse practitioners, anyone who's basically not a physician, okay? And the statute that authorize a non-Florida physician to testify here is 458.3175. And what my friend did in his petition, and he did again in the reply, is he skips the bold language that I just put you. He doesn't quote it. He just acts like it's not there. And so what this statute says is that an out-of-state physician can testify in a Florida court an out-of-state physician is authorized to do three things in Florida court proceedings. The last one we're not here on, can testify in criminal, child abuse, and neglect cases. The next two we are here on, but we're not here on B. But that's what he quotes in his petition. That's what he quotes in his reply. B deals with testimony at trial. A deals with the verified medical expert opinion as provided in 203. And then to get through this, it's just like each statute cross-references another one. And that's why I've laid it out on this piece of paper. But what A tells you is that an out-of-state witness, an out-of-state physician, he's authorized to provide a verified written medical expert opinion as provided in 203. That's the pre-suit opinion, which is different than the trial testimony. And in these cases, we often see you might have one expert at pre-suit, and then you have to get multiple other experts by the time you get to trial. Or you might even not even use that pre-suit expert for whatever reason. So then if you go to step 2 here, what it says is, this is the corroboration of, this is pre-suit. It has to be a verified written medical expert opinion as defined in 2026. Jump to 2026. It has 3 requirements in there. Regularly engaged in practice, holds a healthcare professional degree from a university or college, and meets the requirements set forth in 766.102. Now, my friend will latch on to that last thing and say, see, if you the qualifications are the same for the pre-suit opinion as they are for trial testimony. But it doesn't cross-reference 458.3175. It cross-references 766.102. And if you go to 102, and I haven't been able to put it all here, you go to the main subsection is subsection 5, and there's 3 options under there. Now, we heard a lot today about same specialty. That's not at play at this case at all. Same specialty deals with physicians. We're not here with physicians. We're here with a physician assistant and a critical care specialist. That falls under 5C. And go read the Carmody opinion by Justice Coriel. He points this out because we heard the same argument there. In 5C, they left in the words same or similar health profession, excuse me. They left that in 5C. So why we hear arguments about same specialty when we're not here on a specialist? Because 5A applies only to specialists, a specialist like a neurosurgeon. I'm not sure, but 5C is what applies, and they haven't challenged that. What they're challenging is the other part in subsection 6. Okay, and Carmody, it's dicta, but I think it's right. And frankly, I will tell you, there's a part of our response on page 42 that I don't think is correct in light of this dicta. But if you go to page 43, our alternative argument lines up with this dicta. You have to meet both 5C and subsection 6. So what does subsection 6 say? It says a physician licensed under chapter 458. We'll go back to the top. An expert physician who's from out of state gets a certificate under chapter 458. He's licensed under chapter 458 to do 3 things: testify in cases during criminal child abuse and neglect, testify in medical malpractice cases at trial, and provide the verified written medical opinion. That's the correct statutory analysis. I don't think you have to get there, because whether you agree with me or not, there's no way this trial judge departed from the essential requirements of law, because there is no case out there addressing this. I've looked through every case, including it came up in Mann, I can tell Judge LaRose. It doesn't get addressed because these have all come up in certiorari. Now that we're going to have appeals, they will. My last point that I don't want to miss, I heard this.
And you'll need to make it a quick point because. you're
Okay,
just-
well, our second notice of supplemental authority cited the Sarasota County case that Judge Lucas and Judge Silberman were on the court. In footnotes 4 and 8, you make very clear that when there is a new rule of appellate procedure, it does not apply to the certiorari proceeding that's pending. In that case, the Sarasota County case, I provided as my second notice of supplemental authority. You were dealing with the new rule of punitive damages. What matters is what was the rule in effect on the date of either the order or at the latest when the initiating document is filed. So here, the petition. When the order was entered and when he filed my friend filed his petition, we were under the old rule of appellate procedure. So this court's already answered it. And that Sarasota County case, I did not submit second supplemental authority. Another panel of this court, let me grab it real quick. And I'll file this afterwards. Beck v. Wright, 353 Southern 3rd, 664, adopted your footnote 4 and 8. So there's been 2 panels that have recognized that you do not apply these new rules of appellate procedure to pending extraordinary writ petitions. And with that, and without any further questions, we'd ask the court to deny or dismiss the petition.
Thank you, Mr. Chairman.
May it please the court. in Bonatti, this court specifically stated, the Medical Malpractice Act defines investigation to mean that an attorney has reviewed the case against each and every potential defendant and has consulted with a medical expert and obtained an opinion from said expert. Counsel says you don't have to do that if you're suing a hospital. He's creating a distinction between what has to be done as to a party versus a hospital. Because his theory is, if it's a hospital, I only have to name one. That's all I have to do. Because the statute says any defendant. Their reading is any one defendant, I'm good. But if it has to apply to any named defendant, if it's an individual, why doesn't the same analysis apply to a hospital? Does that make sense? Does it make sense that a plaintiff could sue a hospital and do a pre-suit as to any one doctor they choose, they pick and choose, and then sue everybody? Because under his theory, under the plaintiff's theory, I could go in and Medical Malpractice Act, we don't need to worry about it. I'm going to pre-suit the nursing staff and file my suit against all of the emergency room physicians. That's what they're saying we can do. And that's not what the Medical Malpractice Act says. If you look at this opinion, this court's opinion in Jackman at page *3, and it's the beginning of head note 4.
Fair to say Jackman, I mean, you had two concurrences, a per curiam opinion that I think I was the only one because somebody had to do it. And even the per curiam opinion sounded awfully reluctant about using certiorari for what you're.
Well, and again, I'm going to get to that, Your Honor. That's why I'm bringing this up. It says our court has expanded the scope of certiorari to address not only a plaintiff's facial compliance with 766-2032, but also the quality of a plaintiff's compliance.
Right. And
We're making,
if I remember, is like even when we disagree with, what somebody said, we're bound by the panel to do it. That prior panel is now gone. So.
but we're not only arguing the quality, we're also arguing the facial, and that's still good law. That's still available because at the end of the day, there was nothing in any of those notice of intent, nothing in those opinions that the experts rendered that said anything as to these providers. They were silent. So essentially what we're looking at is I can file suit against the hospital. I don't ever have to pre-suit them. I can name them a month before trial, say, oh, I'm going to bring in this party too. Now, counsel says, oh, well, we'll never be able to get beyond pre-suit. That's not true. We all know that the law says that you have up until the expiration of the statute of limitations to complete pre-suit against any other party you want to name. That would apply just as equally to a hospital. If you come through and there's someone in the records or you didn't find someone in the records, because I think we have two situations. You have a situation where the person is named in the record, which is the situation here, by the way. And you have a situation where we might discover that person later on. You can cure that. All you need to do is initiate the pre-suit to that new party you learned during discovery. So we're absolutely not saying, no, you get it in pre-suit and that's it, you're done. Because I don't think that would be a fair reading of the law. Just as I don't think the plaintiff's reading of the law is correct. It shouldn't be for a hospital. I get to pick whoever I want, any claim I want. And that's enough. That's enough. Because again, what is the basic ability? Why do we have the Medical Malpractice Act? To kind of allow people to look at these claims, investigate, like the Bonatti court said, and determine whether we need to go forward. Very quickly addressing the demonstrative exhibit. The expert certificate, and the law has been clear on this, the expert certificate is to allow an expert from out of state to opine as to a physician, because again, they are the same specialty, they're the same thing. There's nothing indicating that a doctor from Georgia would have any idea about how nursing staffs in Florida work, how physicians assistants in Florida work. That would have to be in their affidavit, say, I have knowledge of this. So what counsel's saying is, well, we're going to break this up into two separate things. No, the expert certificate is only for physicians, and that's very clear in the statute. Again, we would ask that, sorry, last point on the jurisdictional issue. Again, I do agree that Carmody may have taken away the ability to look at the qualifications, but at the end of the day, again, we're looking at facial failure to comply with pre-suit as to these providers, because again, there is nothing in those notices and nothing in the affidavits. Thank you, Your Honors.
Very good. Thank you very much. Thank you both. That concludes the oral argument session for today. We appreciate your being here and we are adjourned.
All rise.
Thank you. Travel safely.
Thank you. Great job.
Good. Meet you in person.
Yeah, finally, huh?